Brad Williams, Labor Compliance Group newsletter. Keep in mind, I'm not an attorney. I do not give legal advice. But my, oh my, I just have to say, again and again, I sympathize for you. If you're doing public works projects in California, man, you got to just keep records. I mean, your records have to be intact, timely, and supportive. What do I mean by that? I'm going to present to you a civil wage penalty assessment. And the key thing here on your part is to recognize that DIR makes mistakes. I mean, it's just, for a professional organization, you really have to look at how inaccurate their data is. And I'm going to point out some key features here that you, as a general or a sub or anyone doing public works, needs to keep in mind in terms of staying compliant. Otherwise, you're going to get hit with a sizable penalty. In this civil wage penalty assessment, this group was fined $70,000. Here we have, it's called the Stone Collector. Now, this project was awarded in 2016. This enforcement action was completed in 2023. For those of you who have taken my course, you're going to realize that I stress some key components. To take my course, my online course, you're going to see how important it is to document your information and keep those records. In any event, project was in Anaheim. This guy, Moutaz Alsayed, was the general. They're going to fine him 80 grand for unpaid prevailing wages, training fund contributions, and other penalties. The procedures, I don't need to walk you through. It's going to be the standard. You're going to have a hearing officer. You're going to have presentation on the part of DLSE. And then if the defendant shows up, he may or she may have an attorney or not. But that's not the point. Let's see what DIR is stating here. It says this party stipulated, okay, this is going to be normal stuff that, yeah, this guy violated California prevailing wage law, et cetera, et cetera. Timely, the request was timely. The enforcement rule was timely. No back wages, et cetera. Now, what we're looking at here is what's DIR charging this guy with? Whether DLSE served the assessment timely, yeah, that's normal. Whether Alsayed paid his employees the correct prevailing wage rate for all hours worked, whether Alsayed paid the required training funds, whether Alsayed is liable for penalties, whether the labor commissioner abused, that's normal language, whether Alsayed is liable for liquidated damages. If you don't know what that is, take my course. Whether Alsayed provided contract award information to all applicable apprentice committees, whether Alsayed employed apprentices in the required minimum ratio, whether Alsayed is liable for penalties. So it is the gamut. It is the A to Z of penalties. And as I've stressed time and time again, DIR has countless penalties that they can assess. I think there's 16 different penalties. Again, if you willingly sign that DIR Public Works California contract, you're going to have to play by these stringent rules. You're doing this voluntarily. DIR expects you to know all these rules. Here we go. There was a renovation project in a city park. All right, no big deal. This guy is going to do some stuff. He's going to do some lighted walking paths. He's going to install some outdoor exercise equipment. Okay, this is superfluous stuff. Here's your contract. May 17th, Anaheim City awarded this deal, et cetera, et cetera. The project went from July 2016 to October 2016. What is that, 4 months? On 2017, the awarding body sent a memorandum to DIR stating the work was substantially completed on November 4th. DIR is going to use this July 25/16 to November 4th as the timelines. Construction service manager recommended that the project is accepted and completed. All right, so that is the timeline. On January 22nd, it was sent to Rule 27, and I'm not going to dive into Rule 27. It's down here. California Code of Regulations. The hearing officer issued an order to show cause why the assessment should not be dismissed or untimely. All right, they're going to get into the legal stuff here. And it says right here, prior to the expiration of the 18-month limitation period, you don't know what this is? Again, take my course. Prior to the expiration on August 14, 2017. Keep that that in mind. We have some timelines here. So August 14th, go back 18 months. DLSE properly served a written request for certified payroll records on Alsayed, the stone collector. Alsayed ignored the request. Keep this in mind. This is DIR's language. Ignored this request as well as a subsequent notice of impending debarment and continues to refuse to provide DLSE with the requested certified payroll records to this day. All right, I'm going to put my opinion in here because DIR right up front in their own language is making these assumptions. Now, here's the irony. If you, as a sub or the general, ever make a DIR assumption, look what happens. You're going to get penalized to no end. Here, DIR makes this assumption and presumes that this guy is intentionally ignoring this request. Keep that in mind because that's going to lead to the ultimate conclusion of this civil wage penalty assessment. Moving on, as a result, the assessment issued by DLSE against Alsayed was timely. Keep that in mind. They like to use this word timely. At a pre-hearing conference in 2021. Remember, this was back in 2016. Here we are, 2021. The hearing officer informed the parties that he was receiving the issues of timeliness for further, they're just going to go into some other rulings. Hearings on July 21st, Alsayed filed a motion, and I love this word, bifurcate the hearings so that evidence would initially be presented on the timeliness issue. That means there's a separation between one argument versus the other. This is a word we use in finance. Actually, it's more in terms of commodity trading. You have a bifurcation of a particular trading environment, but neither here. You need to just reference this into this particular argument. With all the other issues reserved, they're going to go in and the state, he said, she said. So now we're going to have this Sebastian testified for DLSE. Well, she shouldn't have a job. All right, period. She did a horrible job. I'm just leading into what this is going to lead to. I'm not even going to remember her name. This individual testified that she was employed by DLSE as a deputy labor commissioner. Wow. I guess they can hang a title on anyone for whatever reason. She investigated complaints and enforces California prevailing wage laws and regulations. All right, she goes on and testified that she was assigned to investigate a complaint from the Center for Contract Compliance. They are a federally recognized labor management committee. Center for Contract Compliance files this issue against Moutaz doing business as a stone collector. According to DLSE notes, the complaint dated March 8th was received in DLSE. Again, remember, this was nearly 5 months. The project ended in October. This complaint was filed 5 months later. It was forwarded to San Diego office where it was docketed. They're going to go through. And why was there a complaint? It's listed the contractor's address. This is important. It's listed the contractor's address as this particular place in Fullerton, California, as listed in the contract. All right, DIR took this information, or contract compliance, just went online and grabbed this information. Did they do any further follow-up? I can't answer that. This is the record. This is what we have to work with. And again, this is alleged underpayment of prevailing wages, failure to make training fund contributions, and violation of apprenticeship requirements. This Sebastian began her investigation by sending an initial request for documents to both the awarding body and the contract. Among the documents requested were certified payroll records. And according to Sebastian, normal business practices for clerical staff to support us in investigations by serving these documents. That in mind, I'm going to read that again. Normal business practices for our clerical staff to support us in investigations by serving these documents. Accordingly, Lee Lopez, a member of the DLSE support staff, mailed the requested certified and regular first-class mail on June 8, 2017. I know I'm getting kind of micro in terms of this newsletter. The reason being, this is how detailed DIR is going to come after you in terms of a civil wage penalty assessment. It is a comprehensive legal process, and here are the steps. It's going to disrupt you as a general or a sub from your day-to-day operations. The point is, you want to avoid this at all costs, but in some cases, you don't have a choice. DIR can randomly do this, whether their investigation is valid or not. So the request to the contractor was addressed to the stone collector at, and here we have another address, 1201 East Ball, Unit C, Anaheim, California. Alsayed never received either copy of the request, as both were returned to DLSE by the United States Postal Service. Okay. Keep that in mind. Keep that in mind. This is critical. The return certified mail was received by DLSE on June 20, 2017. They were sent out June 8th. It came back on June 20th. The return first-class mail was received by June 27th, with a label affixed, returned to sender, not deliverable at this address. Unable to forward. Meanwhile, and keep in mind here we are on June 15, 2017. DLSE received this letter on June 27. Meanwhile, on June 15th, the awarding body responded to San Sebastian's request. Among other things, it submitted copies of Alsayed's payroll records. All right, so there's some redundancy here. It's unusual here where the awarding body will actually have payroll records. This is unusual. So this particular group, Anaheim City. So Anaheim, their compliance department was doing a great job. Anaheim gave the record to DIR. However, these records were not certified and appeared to be incomplete, as certain required information was omitted and records for several weeks were not provided. All right, but it's a starting point. You can interpolate this information, and you can fill in the missing parts if you need to. And again, DIR, they made this assumption that Alsayed ignored this information. Well, how can you ignore information if you never received it? So the awarding body's response also included copies of its contract with Alsayed and related documents. The contract identified the stone collector as the contractor and was assigned by this guy, by Alsayed. All right. And the contract address was Skyline Drive, Fullerton, California. The request for information was sent to this address. Sorry, folks, I'm gotta move around here. East Ball Road, but the contract was signed right here. Again, you gotta say thumbs up to DIR for their competence, because pretty clear the accurate address is Skyline Drive. And I don't know where this 1201 Ball Road came from. Now, it could be from, I'm sure the answer's down below, but this could be the Secretary of State's information on this guy, because you have to register for the state of California. As a sole proprietor, you don't have to register with the Secretary of State. Declaration, opposition, stated that the request is sent to an address registered. Here we go. See, it was sent to an address registered with the California Secretary of State by the stone collector. Wow. Okay. So again, you have to point your finger at DIR, because this information with the Secretary of State, it could be dated. It doesn't have to be tied to the contractor's information. That's what they mean by bifurcation. Attached as Exhibit H to a request for judicial notice accompanying Assad's motion to bifurcate is a copy of DLSE's record of business entity search detailed from the Secretary of State's website. That means the bifurcation is you're looking at two different sources of information and they don't match. It shows that the status of the stone collector has dissolved. Really? DIR? Come on. If it says it's dissolved, how can you say this is an accurate address? All right. Although it lists the Ball Road address in Anaheim as a corporate address, it lists Alsayed as the agent for service and lists another address, Santiago Boulevard, Orange County. This is not unusual. You can have addresses all over the place, but in the end, your contract address should reconcile to your current address. Maybe there's a lot of moving parts. Maybe Assad is a genius. He outsmarted DIR. I don't know. I'm just interjecting some of the thoughts that individuals could entertain. But I'm not saying any of this is intentional. But we have 3 different addresses. Is there any record that DIR actually tried to call the guy? Well, let's see. Well, we're going to go on here. Sebastian testified that after the packets addressed to the stone collector on Ball Road came back to her, he did research on why they were returned. All right. I did look at the contract provided by the awarding body and its material. So I did confirm that the contract stated that it was between the city of Anaheim and the stone collector. And again, Alsayed, I also found through the contract material the contractor state license number. And so I went on the Contractor State License Board website to look at the contractor's mailing address, as well as looked into DIR's contract registration because the public works contractor is required to register. The first thing I do before I even acknowledge and want to work with an individual, what's the first thing I check? Contractor State License Board. The first thing I do, I want to see if it's valid. The second is I check the contractor's registration information. Then third, I go online to see if the company's valid. I do this before I even sign a contract with the company. And here we are, DIR steps in after the fact to do their research. All right, no wonder the system's so damn screwed up. So here we go. So I went ahead and also verified the contractor's mailing address through the DIR registration. Once I gathered this information, I was able to confirm that the contractor's mailing address is Skyline Drive, Fullerton, California. Wow, isn't that amazing? Here we are, 5 years into this deal, and had DIR initially confirmed this information, we wouldn't be going through this. The guy wouldn't be dealing with this possible $80,000 fine. Anyway, moving on. Stands to the best and stated that she had access to the contractor license board on 2017 and that she did not recall it having the Ball Road address. They're going to go in, and this is DIR questioning because the defendant was never questioned because they don't know where the guy is. Stands to the best and testified that she provided the Skyline address to support staff so that she could send out a request for payroll records to the contractor at the correct mailing address in Skyline. Okay, this is 2017. She again addressed the envelopes to the stone collector, but used Assad's current address in Fullerton. The request was again sent by certified mail. The certified envelope was again returned to DLSE by the Postal Service, but the first class envelope was not. Let me reread that. The request was sent by certified mail. The certified envelope was again returned to DLSE by the Postal Service, but the first class envelope was not. Alsayed did not respond to the request. Since the Sebastian assumed, here we go again, that he received the request because the ordinary first class mail was never returned by the U.S. Postal Service. As I point out again and again, DIR, their staff are not the sharpest knives in the drawer. This is common sense stuff. Making assumptions. DIR can make the assumptions, but if you work for this agency, you cannot make any assumptions. The irony, there's an $80,000 penalty here, and this individual, recognized as a deputy director who's supposed to know what they're doing, clearly shows incompetence across the board. Not only Sans Sebastian for her lack of management, but also her entire staff for not doing comprehensive research when they disrupt an individual's lives and send out a possible erroneous $80,000 fine. Shameful on DIR. Really, really inconsiderate, unprofessional, and there should be some reversal. But on the other hand, this individual and everyone else who signs a public works contract needs to be aware of this crap that DIR and their incompetence and the stress it can do to you and your entire organization. When asked by DLSE counsel what she did next, Sans Sebastian testified because the ordinary first-class mail was not returned by the U.S. Postal Service, it was then determined that the contractor was to provide the records within 10 days of the request for payroll records. The records were not provided by the contractor, and a notice of impending debarment was sent to Skyline. This is in 2017. Keep in mind, we have all kinds of addresses going on here. We have the Skyline address, we have the Santiago Boulevard, and then we have the other address. So there's 3 addresses, with Fullerton being the primary address. Thus, on April 7th, and keep in mind, this is an ongoing deal. They keep sending this stuff out, not knowing where this individual lives. Is there any recognition of DIR actually calling the guy? So on April 27th, this is 2020, back up here. So this is June 8, 2017, when they sent out this request for payroll records. Here it is now, 3 years later, DLSE employee Gloria Ayala served the notice of impending debarment on Alsayed at the Skyline address 3 years later. Via ordinary first-class certified mail, the certified mail receipt was again returned to DLSE, apparently signed by Assad on April 29, 2020. 2020. Here we go again. We're at the Skyline Drive. We have ordinary mail, and we have certified mail receipt was returned to DLSE, signed by Alsayed. All right, so there's some inconsistencies here. The same address, but now the request is signed. What happened with the other information in that 3-year period? May 12th, Alsayed sent a letter to San Sebastian. 3 years later, is still working for DIR. The stone collector furnished all certified payroll records to the city upon project completion, and unfortunately, we did not retain any information for more than 3 years after any project completion. We do apologize for not being able to assist in this matter. All right, good argument. And technically, he's correct. DIR, they don't have a written policy about, but Davis-Bacon does. So I always recommend you keep your records for at least 5 years. On June 20th, San Sebastian sent Alsayed an email stating that she had completed her audit and was sending a demand letter giving him an opportunity to settle the case. Can you believe this? They want to settle the case without any cause. So DIR, again, in their arrogance, is going to send this civil wage penalty assessment to you, then hold you to the fire. They're going to put you into the guillotine, and then you either pay up or we're going to move forward to a hearing. You need to be careful about when you sign that contract, what you're going to be under in terms of this enforcement in individuals like this. On July 19th, Alsayed responded by mail requesting more time to go over stored records. He also stated that he had found some checks paid to employees directly besides regular payroll checks. Okay, so the guy's going out, he's making an effort here, and provide copies of 14 checks. On August 3rd, San Sebastian responded by email stating that she was unable to provide credit for the checks and requesting that he submit any additional documentation. DIR is the 800-pound gorilla, and you can see right here, this illustrates what they're going to do to you when you sign that public works contract. On August 4th, Alsayed sent an email saying, I've consulted my attorney and he advised me to let you know that the statute of limitation has passed, and unfortunately, I have no other information to provide to you. Good for him. I applaud this. All right, San Sebastian responded on August 5th, stating that if no further information was provided, she would move forward with the civil wage penalty assessment. Testifying on his own behalf, Alsayed stated that the Ball Road address had been the mailing address for a corporation he operated, the Stone Collector Inc., which is no longer active. Dissolved that in 2005. DIR, when you do the Secretary of State search, it's going to say active or inactive. Well, it showed inactive, so we can cross Ball Road off the list. He had not been at the Ball Road address since 2008. At the time he signed the contract to the project, he had a contractor license in his own name. Alsayed testified that the first communication he received from DLSE regarding the project was the notice of impending debarment in 2020. Asked if he remembered receiving any letters at the Skyline address prior to 2020, he responded, no, I didn't get anything. No. All right, so we have one of these he said, she said deal. This is a normal practice, and what's going to happen now is DIR is going to try to impeach this guy. He's going to try to pin this guy as to, well, in 2020, you signed some documentation that we sent to you, but you ignored the information in 2017. So tell us what's going on here, Mr. Alsayed. On cross-examination, Alsayed testified that the Skyline address was his residence and his current address, where he received both business and personal mail. Asked by DLSE if he had ever had issues with receiving mail, and Alsayed responded, yes. I did, actually, yes. It's on a regular basis. If the regular driver is not available, they send somebody else, and he puts the mail, my mail, in somebody else's box, or he puts the neighbors in my box. So it happens. Well, to interject, it happens all the time. I do have some missing credit card bills and so forth, but it's normal. He further testified that he had just received a check that was mailed to him in June. And again, I don't know what the dates look like here. I just received it today. I don't know where it has been. Asked if he would have paid attention to something that was addressed to the stone collector, Alsayed responded, yeah. Anything that comes in the mail, I check it. Whether it's regular junk, I check all of it. Asked if something addressed to the Stone Collector Inc. with his name on it would be junk mail, he answered, no, it wouldn't be junk. No. This all comes down to this guy saying, look, I'm trying to do the best I can. And here, DIR is pointing a gun at the guy saying, you screwed up. I could just stop here and allow you to make comments as to what you think, but I'm sure you want to know what the final outcome is here. Now, from here, we have this discussion, and I've gone over this enough time. This is the California prevailing wage. This is a boilerplate. I'm not going to go down this thing. This is the Lasardia argument about if you do work as in public works, you're going to have to pay prevailing wages. That's fine. And then when DLSE determines a violation, no, okay, we know that DIR has a heavy hand and they're going to fine you for sneezing if the sun comes up. In this particular case, we're going to go into what really happened here. We're going to go into the statute of limitations issue. And here, section subdivision sets the limitation period. Section 1741 subdivision is a statute of limitation for service of civil wage and penalty assessments, 18 months. The assessment shall be served not later than 18 months after the filing of a valid notice of completion in the office of the county recorder in each county. Remember, I said we had those timelines, and those timelines were 2016. You're going to have a timeline here, and I guess right here we're going to have some timelines. You have an 18-month period. DIR is going to wait to that 18th month, so there's however many days that is. So they have up to that last day to file this civil wage penalty assessment. So here, the statute of limitations began to run on February 22nd, 2017. That's when the final notice of completion was recorded. When I talk to my clients, when you're out there doing your project, I don't care if it's a $2,000 project or a $25 million project, always ask for some notice of completion, be it a handwritten, we acknowledge we're satisfied and complete, or something to that nature, so you can put this in your records, because that's when the clock begins. And in a lot of instances, when the clock stops, when the clock begins, and here, that's when the clock begins for this 18-month period. Here, the awarding body executed notice of completion. The awarding body, that's Anaheim. Notice of completion of the project on February 22nd, which was recorded by Orange County on March 2nd. The notice of completion stated that the date of completion was November 4th, 2016. Notice the timeline here, and this is always a point of argument. Look how long it took for Anaheim to record this thing, and you completed the project on November 2016. Technically, when does the statute of limitation begin? Well, here they're using this 2017. Good attorney is going to argue, no, this project was completed in 2016. Under Civil Code Section 9204, a public entity may record notice of completion on or within 15 days after the date of completion. And the notice of completion shall include the date of completion. There are two ways that this statute makes clear that a notice of completion recorded more than 15 days after the date of completion is invalid. First, as quoted above, the statute expressly does not permit recordation of a notice of completion more than 15 days after the date of completion. So this 3-month deal, if rules like this weren't in place, this awarding agent, in this case Anaheim, they would just ignore, recording this information, and clearly they did. Second, the statute states that if the notice of completion states an erroneous date of completion, the notice is still effective only if the date of completion is 15 days or less before the date of recording. Here, the notice of completion stated the project was completed November 4th, 2016, and there was no evidence disputing the completion date. The notice of completion was filed nearly 4 months later on March 2nd. Accordingly, the notice of completion was invalid and did not commence the running of the limitation period under Section 1741. Whoever pointed this out, bravo, because, hopefully the attorney, for if Alsayed ended up having to bring on an attorney, I guess this would be the first argument. Since there was no filing of a valid notice of completion, a determination must be made under Section 1741 subdivision A as to the date of the acceptance of the project. Final acceptance has been defined as the date at which someone with authority to accept does accept unconditionally and completely. As I said, always get some type of notice of completion. It is not necessary that the acceptance be embodied in a formal resolution. In other words, if you have something written in your documentation recognizing what you think is the completion date that might help your argument. Again, crossing the T's, dotting the I's. Now, they're going to go in and they're going to mention all of this stuff here, and I'm not going to go through it. Well, maybe. Let's see. The facts of this case are similar to those of Madonna. On February 22nd, the awarding body construction service manager sent a memo with the following, that the director of public works accepts the construction of improvements. Okay, this is recognition that the project was complete on February 22nd. So that's your start line. That's when the statute of limitation began. The memorandum went on to say that the work was substantially completed. The same day, the director of public works signed the notice of completion. And you got to recognize the procedures and the process. Under the hood, the stuff we never see. That's why these rulings are helpful. So you get an idea of what DIR has to go through in order to cross their T's and dot their I's. The recording of the notice of completion was untimely. The administrative process preceding it demonstrates complete and unconditional acceptance of the director of public works within the meaning of Madonna. The construction service manager's recommendation here is analogous to the state highways engineering recommendation in Madonna. By following these recommendations, the awarding body, director of public works, manifested acceptance of the work, just as the state director of public works manifested acceptance by endorsing the interdepartmental communication in Madonna. The public works was accepted on February 22nd. The 18-month limitation period began to run on that date. So this is what it takes in order to determine when that statute of limitation begins. So now there is this thing called tolling. Trust me, it is a killer in terms of the burden on you. Because, let me give you an idea. Subdivision 2 provides in part the period for service of assessment shall be tolled for the period of time that a contractor or subcontractor fails to provide in a timely manner certified payroll records pursuant to a request from the Labor Commissioner. At issue is whether this tolling provision applies to the facts of this case. So in other words, DIR sends out that request for certified payroll information. This is, I don't know, it's the 17th month of this deal, 17th month after this completion timeline. You have 10 days to get that information to DIR. They're still within that 18-month window. If you don't provide that information, guess what? That's a tolling period. So if this tolling goes on for a year, guess what? That 18-month window is still open and you're still subject to penalties. If you fail to send out a DAS 140 and a 142, you technically could be fined for this tolling period. And I've seen it. Employees on public works must keep accurate records, among other things. Okay, this is just going on to the same stuff I repeat over and over about record keeping. This is consistent with the requirements of all the payroll information that you need to provide. Within Section 1776 subdivision requires a contractor to file certified copies of payroll records within 10 days. Thus, by the express statutory language, the contractor must receive the request for the limitations period to be told. On June 8th, DLSE had in its file the correct identity and address of the contractor for the project. Yet, for reasons that remain unexplained, this is a clause that you need to keep in your back pocket because there are many, many instances that there are reasons for issues within DIR that are never explained. DLSE sent by certified mail, and they're just going to go in and say they sent the information either to the wrong address or it was never received. The one and only attempt DLSE made to serve the request in Alsayed at its correct address came more than 2 months later on August 14, 2017. The dispositive question in this case is whether or not Alsayed received that request. California Evidence Code Section 641 provides a letter correctly addressed and properly mailed is presumed. Again, they use these words, assumptions and presume, to have been received in an ordinary course of mail. This presumption is not conclusive, but rather a presumption affecting the burden of producing evidence. I know I'm getting into the nitty-gritty here, but this is important. Here are the steps that are looked at. The statutory requirements that go into play if something goes wrong and DIR believes that you intentionally underpaid a worker. They're going to go to this extreme. So the effect of presumption affecting the burden of producing evidence is to require the trier of fact to assume the existence of the presumed fact unless and until evidence is introduced which would support a finding of its non-existence. In other words, prove unless you can't prove. I know that doesn't make any sense. Upon presentation of appellant's detailed, credible, and unimpeached evidence of no actual notice, the presumption such notice ceased to exist. The only remaining effect of the proof of service declaration was to enable the trial court to draw an inference that was appropriate. In other words, if the guy said, look, I never received this information, what else can you say? You're lying? Well, so what? If you're lying or not, it's up to the judge to determine the credibility of that statement. And they're going to go on and saying, look, similarly, a trial court found that a notice had not been received where the defendants introduced evidence that they had mailed a letter and it was never returned to them, where plaintiff's office manager, Carpenter, testified that the letter had never been received in his office. The Court of Appeal affirmed the trial court's decision holding that Mr. Carpenter's testimony constituted substantial evidence to sustain the above finding. So again, it's going to go back to whoever is hearing this case, whether Mr. Alsayed was truthful. On August 14th, the DLSE again attempted to serve the original request dated 2017. The DLSE again addressed the envelope to the stone collector, but used Alsayed's current address in Fullerton. The request was again sent by certified mail and first-class mail. The certified envelope was again returned to DLSE by the Postal Service, but the first-class envelope was not. Alsayed did not respond to the request. Sebastian assumed that he must have received the request because the ordinary first-class mail was never returned by the U.S. Postal Service. You know the saying, when you make an assumption, I'm not going to go down that any road. You know what the final conclusion. Alsayed, however, testified he never received the request, and in fact received no communication from DLSE regarding the project till he received the notice of impending debarment. Is there any record here that DIR called the guy? Really? I'm shocked that a simple phone call to the stone collector, to whatever phone number he listed, was accurate. An email address. Common sense. Common sense, ladies and gentlemen. Look, you can call and verify the address. You can email and verify the address. My goodness, my goodness, my goodness. If you're still hanging in there, thanks. Well, I'm sorry it takes forever in order to discuss these, but it's important. And I do this to help you out. I know you're thinking, I'm a contractor, I'm a subcontractor. Why should I worry about that? Because in the end, you're going to be shocked at the final ruling. Alsayed's credible testimony, and that's important. Hey, to support this channel, take a look at the various courses I provide. Understanding California DIR Labor Compliance Rules and Regulations. This course, Understanding California DIR Labor Compliance Rules and Regulations, hammers home exactly what I'm talking about. This is a 6-hour course. It covers the details. It covers instances related to this civil wage penalty assessment. Federal Davis-Bacon FAQs. This is what I call a handbook. This is a guide to answer those FAQs related to Davis-Bacon that may be posed, but you don't have the answers to. Very thrifty tutorial. San Francisco local hire regulations if you're doing work in the Bay Area, be it public works or private. It applies to both. Take a look. And it also has a chapter on public works and the requirements that you need to follow. Navigating DIR websites, there's more there than you think. There really is a lot more there than you think. This is a complement to the labor compliance rules and regulations for DIR. If you take A, you need to take B. California DIR Prevailing Wages FAQs, similar to the Davis-Bacon FAQs, just a nifty go-to handbook, if you will. A quick course on DIR Prevailing Wages and a lot of insight. I interject. There's also a Q&A to the FAQs. No. Federal Davis-Bacon Contractor's Guide if you're doing Davis-Bacon. This contractor guide is go-to. It covers pretty much all agencies, though I reference a couple. It's an umbrella and will apply to all federal public works projects. And then consulting, if you need one-on-one training, I still do that for both Davis-Bacon and DIR. If you need monitoring of large projects, 5 million and above, I'll do that. And if you have unique, one-of-a-kind questions, email me, call me, and I'll take a look and see if I have that answer. If you like this newsletter, subscribe, give me a thumbs up, hit that like button, and be sure to check out all the links below So let's get to the bottom line of this civil wage penalty. Alsayed's credible testimony that he never received the August 14, 2017 request for certified payroll records overcame the presumption in Evidence Code Section 641. Up here, remember I said there is that evidence deal as to whether U.S. mail is guaranteed to be an acceptable means of receipt. Well, you could see that the courts have their own opinion. Thus, Evidence Code Section 604 requires the trier of fact to determine the questions from the evidence without regard to the presumption. Alsayed's testimony is unrefuted. Therefore, the director finds that he never received the request for certified payroll records prior to the April 2020 notice of impending debarment. The assessment was not served timely. The assertion that the assessment was served untimely constitutes a statute of limitations defense. The statute of limitation is an affirmative offense, and its elements must be proved by the party asserting it. And they're going to go in, they're going to use this case. Thus, Alsayed had the burden of proving that he did not fail to provide in a timely manner certified payroll records pursuant to a request from the Labor Commission within the meaning of Section 1741-1. Alsayed met the burden by proving that he received no request for certified payroll records prior to April 2020. Accordingly, the statute of limitations set forth in Section 1741 subdivision was not told. Again, that's what's critical here. As stated above, the 18-month statute of limitation set forth in Section 1741 subdivision A began to run on February 22nd, 2017. Because it was not told, the 18-month period ran out in August 2018. DLSE did not serve the assessment until 24 months later, August 28, 2020. Therefore, all other issues are moot. In review of the findings that DLSE failed to serve the assessment timely, all other issues are moot. The assessment was served timely. All other issues are moot. The civil wage and penalty assessment is dismissed as untimely. Thanks for hanging in there. It was a long process, but critical. You can see what DIR is going to go through. They think underpayment of prevailing wages. This information, I'm going to leave a link. I just grabbed this directly from DIR. So give me your comments. Let me know what you think. You're doing public works contract, but this is what you're subject to. Brad Williams, Labor Compliance Group. Thanks for watching.